Hi, my name is Beth Blackwood. I am counsel and director of the First Step Act Resource Center at NACDL. And we are here today to talk about ways in which an attorney can turn their existing compassionate release motion into a successful commutation petition. And I'm happy to welcome Gillespie from the Office of the Pardon Attorney. Kira is an attorney advisor at the Office of the Pardon Attorney, where she has worked since 2010. She's currently in a supervisory role at the office, where she leads a team of attorneys who review and make recommendations on matters of executive clemency to the pardon attorney, the deputy attorney general, and the White House. During the Obama administration, Kira was the primary coordinator of all executive clemency grant days conducted under the department's clemency initiative, drafted most warrants for clemency, trained and supervised attorneys from across the department detailed to the office. We're so happy to have you here today. Thank you so much. And the reason we wanted to talk about this subject is that the majority of NACDL's members are criminal defense attorneys, and many of them have represented individuals in post-conviction proceedings like compassionate release motions. And those have a large focus on mitigation, discussing where the client is now after a period of incarceration. And for some folks, the last time they've worked on a case might be a sentencing memo before the client's sentencing hearing, which of course also has a huge emphasis on mitigation as well. So in many respects, what makes a successful compassionate release motion or even a successful sentencing memo can be what makes a clemency petition successful as well. So I'd hope that you could speak with us today about ways in which defense attorneys can take something like an existing compassionate release motion and convert elements of that into a commutation petition. So first off, could you talk with us about the main differences between a compassionate release motion and a clemency or a commutation petition?
Well, first, I just want to say thank you for having me today. I'm happy to be here. To answer your specific question, I think one of the biggest differences between the two is that the petition for clemency should be signed by the client themselves. We require their signature in order to access all the documents that are related to the case. So we're getting them from places like the Bureau of Prisons and from probation offices. And so it's helpful to have their direct signature. We'd also ask that people please fill out the commutation petition. You can certainly have references to it and just fill out the main portions and say, see this memo here for the longer questions, but we would appreciate the form itself coming into the office. We really do value candor and honesty in our clemency petitions, and we're not looking for it to be an adversarial process. There's no back and forth between the parties. So we appreciate somebody being really upfront and honest about their past, what happened with their offense, and how they've changed and grown in prison. We really do want to hear those things from both the advocate for the person as well as the person themselves.
So that's how they're different. There's this form that has to be filled out that you can find on the pardon attorney website, and then there's an accompanying petition that probably does share some similarities to a compassionate release motion. So can you talk specifically about how a compassionate release motion, which has a 3553A section, how that would be similar to what you're looking for in a clemency petition?
So I think one of the big things that I think would be really similar is sort of a reentry plan focus. And when you do that, it's helpful to have as much specifics as you can, to have, people who are willing to provide the person housing, people who may be willing to employ them, to have comments from those persons who are willing to offer those services themselves. So I think that's one commonality is establishing reentry plans for the petitioner. Another one might be some of the unique history and characteristics of the petitioner that, landed them in this situation and how they can interact with other persons in their community to re-enter the community in a positive way going forward.
So the reentry plan, what are the types of things that you're looking for? Not probably is what it's great to just have it laid out, but support letters or those types of things that can help with that as well.
Absolutely. I think the inclusion of support letters and, as specific as they can be in how they're going to offer their support, I think is helpful. So, not just saying, I miss this person, but how tangibly can we assist them in transitioning back into society, I think is a really helpful thing for submissions to have. You also want to focus on the your client's record in BOP, like how they have programmed, what classes they've taken, maybe things that they've done outside of the ordinary prison programming options that are available to them. Certain people have taken correspondence courses that aren't just routinely available to everyone. And so highlighting anything that you've done outside of the ordinary is certainly something that both pro se applicants and people who are represented would want to do.
Right. And I would just point out that looking through a lot of compassionate release motions that have been filed for an attorney looking to file a clemency petition is a way to get some really good ideas of how to use BOP documentation and sort of mine it to find really good arguments for the client. I mean, I'm sure that you guys have combed through the BOP documents yourself quite a bit. So to prevail in a compassionate release motion, one of the criterion that has to be proven by the defendant is that there's an extraordinary compelling reason. And there's different criteria that the courts look at, but often the medical conditions of the client, if they're very sick or terminally ill, their age in prison, or the family circumstances, those are sort of the traditional compassionate release criteria. Are those also things that the Office of the Pardon Attorney are paying a close attention to as well?
So all of those things are things we look at during the clemency petition. We'll source information from BOP to get medical records for somebody who has an elevated care level in their institution. And so we'll try to track down those medical records and get a complete look at that. Extraordinary family circumstances are, of course, something that the petitioner themselves would probably have to advise us of. And anything that you can include to verify some of those things is helpful. I've had petitioners submit things from a spouse's doctor, verifying a medical condition, or from a social worker about the placement of their children, or things along those lines. All of that, if it's relevant, is helpful.
Right. So just really, there's a large scope of different types of material that that an attorney could bring, or that you all would look at to sort of look at these arguments and make that determination. There's not one fixed thing. There's really a large scope.
Well, every case is unique, and so it's hard to give you a very specific thing that applies in every single case. But everyone has connections outside of prison. Everybody has programming that they've completed in prison, and everybody has their reasons for why they want to return home. And so whatever those specific reasons are, going specifically into those is helpful. But including all of that information, whatever it may be, whatever the underlying issue may be, including all that information is always going to be things that we're going to look at and we would want to see from a petitioner.
So in addition to these traditional factors, an area that's grown a great deal in compassionate release, and NACDL has been very involved in this, is this lower sentence today argument. Mm-hmm. So this is the fact that an individual was sentenced usually quite some time ago and received a very long sentence. There have been intervening changes in the law that make it so that if that individual was sentenced today for those same offenses, mm-hmm. would likely have a much lower sentence today. And I know this was a factor that was important during Clemency 2014. So is this still something that the Office of the Pardon Attorney is paying close attention to as well?
Absolutely. General disparity is always something that the clemency process has been focused on. And so there have been different aspects of that over time. And as you highlighted in 2014, essentially what I would like to call like temporal disparity, like the difference in when you were sentenced versus how you would be sentenced now, is something that we looked at. And that's something that we continue to look at. But we also look at disparities in geographic sentences, disparities within conspiracies. There are certain to be some disparities that happen. Obviously, the leader of a conspiracy is more likely to be sentenced to a longer term than, say, a minor participant in the conspiracy. But if there is something that doesn't follow that general logic, then pointing out those types of disparities is something that we find valuable.
So disparities across the board are fair game.
Right.
So it's interesting you talk about geographic disparity, because I think that's really important with this lower sentence today issue, because it's very circuit specific in compassionate release cases about where you can bring these motions. There's some places where at this time it's foreclosed. You can't bring them at all. So does that play any type of role when you're reviewing these cases about whether or not this individual could bring this motion in their court if they came from a district where that wasn't available?
I would say that is always a factor we consider, and just generally we tend to consider the existence of alternative reliefs. One of the very clear standards we have is somebody has to finish their first appellate process in order to apply for clemency, because if they have the opportunity for relief from the court in the appellate process or in their first 2255 motions, we would just be duplicating effort that I think the court can address better. So we're always looking at the existence of alternative relief and whether or not there is any alternative relief for a person, and then that's a factor in whether or not the clemency petition might have merit.
So I wanted to turn briefly to the issue of old law prisoners. So these are individuals who were sentenced before 1987, and they do not have compassionate release available to them. So they are some of the older individuals in the prison population, and they cannot apply to the district courts for a reduced sentence through the compassionate release mechanism. And I know there's pending legislation right now to try to broaden that to them, but right now it's unavailable. So is that an area that you also are looking at? Individuals with can they apply for commutations, and is that something that you all are paying attention to?
Anyone who's not currently challenging their case in court can apply for a commutation. Obviously, they have to have a federal conviction, but other than that, those restrictions are the only ones that are available, so they absolutely can apply for commutation of their sentence. And of course, that would be a factor that we would look at and consider when we're reviewing their petitions.
And just sort of a practical question, many attorneys are going to be supplementing their client's pre-existing pro se petition. And you can go on your great website with the great FAQ, which I highly recommend people look at, and you can look to see if your client has a pending petition. And so if someone wants to supplement that petition, what is the best way to go about doing that?
So if they're simply supplementing the petition, we will accept mail. Generally, we prefer email just because we have a digital office and we digitize everything. So if it's already digitized, that's one step out of the process, but we will accept postal mail if that is the best way for a person to reach us. There's no need to send duplicate effort, so you don't have to email and send the U.S. postal mail. But just referencing the case number that our office has assigned to the case is going to be the quickest way to get to have us identify the case and have the mail be associated with the case by our staff.
And how about, is there any way for the attorney to find out to get the original pro se motion, determine what needs to be supplemented? What's the mechanism for that?
Absolutely. So if an attorney wants to get the original petition or any supplemental petitions, they can submit something called a certification of identity form, and it will simply be signed by their client, and they will name their attorney as the person to whom files can be sent. That form is generally available on the DOJ website, but you can also email our office and request a copy of it. I don't think it's quite posted on our website yet as a downloadable PDF, but I know we are working on that.
So any other tips that you could give to attorneys who are just some broad, pointers for attorneys looking to supplement or file a commutation petition for their client?
So I would say that attorneys should let their clients speak a lot and present a statement of the reasons why they want clemency. I think that's very helpful. It's always interesting to hear it from the attorney, but it's far more compelling, in my view, for us to hear it directly from the client. Sources of anything that they cite, such as the support letters, or if there's an extraordinary family circumstance, including the background information that helps us verify that, is always very helpful. I would just say that the vast majority of our applicants are pro se people, and so these are the types of things that petitioners who represent themselves can also do is provide these sort of support letters, can provide statements of the reason why they're seeking clemency, can talk about what they've done in prison. So I want to emphasize that it's that somebody does not have to be represented by an attorney in order to be a successful clemency applicant. And across the board, we try to treat everybody the same. And so I want to make sure that pro se applicants know that they can do these steps as well.
Well, thank you so much. I appreciate your time and for you coming here, and thank you for all your hard work.
Well, thank you.